Good day, viewers. My name is Tomisin Farinola, a penultimate law undergraduate from Harvard College, Abeokuta, and a graduate intern at HARLEM Solicitors. I'll be presenting on the topic, Legal Provisions for the Lawful Interception of Communications under the Nigerian laws. An interesting topic for you to sit down, take a glass of water, and kindly pay attention. Dear viewers, since the early days of electronic communications, communicating individuals have generally had an expectation that communications remain private and not accessible by the state or third parties. These general expectations of people that communications remain private and not accessible by the state or third parties is based on the fundamental right to privacy or the right to be left alone, enshrined under Section 37 of the 1999 Constitution of the Federal Republic of Nigeria as amended, which provides that the privacy of citizens, their homes, correspondence, telephone conversations, and telegraphic communications is hereby granted and protected. In the same vein, Article 12 of the Universal Declaration on Human Rights provides that no one shall be subjected to arbitrary interference with his privacy, family, home, and correspondence. Based on the foregoing provision of Section 37 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and Article 12 of the Universal Declaration on Human Rights, it's very important to note that to every general rule, there is always an exemption. This means that despite the fact that each and every one of us is entitled to a right to privacy, the law provides certain legal limitations to these rights. Therefore, the general expectations of people that our communications remain private and not accessible by the state enables law enforcement and security agencies to carry out lawful interception of communications. Dear viewers, you might be wondering what lawful interception is. Lawful interception has been defined as legally authorized process through which communication network or service providers give authorized officials the access to the communications of other individuals or organizations. According to Section 157 of the NCAA 2003, which provides for the interpretation section, it defines lawful interception as the legally authorized process or the monitoring of telecommunication network for the purpose of enabling law enforcement and security agencies conduct criminal investigations or conduct forensics while pursuing a wrongdoer. Dear viewers, it is very important to know that for the interception of communication to be lawful, it has to be carried out in accordance to due process of the law, in accordance to specified conditions. And these regulatory laws, which provides for the lawful interception of communication, are number one, we have the NCAA 2003. Number two, we have the Cybercrime Act 2015. And number three, we have the Terrorism Prevention and Prohibition Act 2022. Starting with the legal provisions for the lawful interception of communications under the NCAA 2003. Under Section 157 of the Interception section of the NCAA 2003 defines interception as the oral or the acquisition of content from any communication network through the use of electronic, mechanical, or any other equipment or apparatus. According to Section 147 of the NCAA 2003, further defines interception capability as the capability of a network service provider to intercept communication. More importantly, authorized interception under the NCAA 2003 has been defined as the capability of a network service provider to intercept communications given on the provision of Section 148 sub 1c of the NCAA 2003. And what is Section 148 sub 1c of the NCAA 2003 talking about? It provides that the Nigerian Communications Commission may order the lawful interception of communications and also for the purpose of conducting investigations. This Section 148 sub 1c of the NCAA 2003, it provides that the NCC has the autonomy to order the lawful interception of communication even without judicial authorization. This means that the NCC has the autonomy to carry out lawful interception of communication, provided that such is conducted in accordance with public policy and is not negating the principles of natural justice, equity, and good conscience. It's very important to know that according to Section 70, rather, of the NCAA 2003, it gives mandate to the Nigerian Communications Commission to establish regulations and guidelines to guide the various telecommunication activities. And one of the subsidiary legislation established under the NCC is the 2019 regulations for the lawful interception of communication. And according to Regulation 2 sub A of the 2019 regulations for the lawful interception of communication, it provides and establishes the legal regulatory framework for the interception of communications. According to Regulation 8 of the 2019 regulations for the lawful interception of communications, it provides that private network service provider can also intercept other private network service provider, provided that both parties consented to the interception or when the interception was conducted by a party who, in ordinary course of business, is required to monitor or record such communications. According to the 2019 regulations for lawful interception of communication, it provides that before law enforcement and security agencies carry out lawful interception of communication, they must get an interception warrant from a judge of a federal high court. And before a judge of a federal court issues such interception warrant, such law enforcement and security agency must endeavor to prove the following grounds. Number one, in the interest of national security involving imminent danger to Nigerians. Number two, for the purpose of protecting and safeguarding the well-being of Nigerians. Number three, for the purpose of conducting investigations, for the protection of public safety, and also for the purpose of defense. And lastly, for the purpose of giving effect to the International Mutual Assistance Agreement. According to 2019 regulations for lawful interdiction of communication, it provides that not just any law enforcement and security agencies that can apply for this interception warrant. It provides that only the National Security Advisor or the Director of State Security Services or any of the designee whose rank is not below the Commissioner of Police that can apply for this interception warrant. According to 2019 regulations for the lawful interdiction of communication, Order Regulation 16 sub 1, it provides that law enforcement and security agency must also observe the rule of confidentiality while intercepting communication. While on the NCC part, the NCC also has the responsibility to observe the rule of confidentiality with any of its logbook granted by a judge of federal high court for any interception warrant, whether such interception warrant has been renewed or cancelled. And according to Regulation 18, which provides for the penalties for any law enforcement and security agencies who fails to comply to the 2019 regulations for the lawful interdiction of communication. It provides and imposes a fine of 5 million naira or a fine of 5,000 naira continually since the offense still persists. Dear viewers, can you let us proceed to legal provisions for the lawful interdiction of communications under the Cybercrime Act 2015? According to Cybercrime Act 2015, it criminalizes unauthorized interception of non-public data transmissions and establishes legal and regulatory framework for the interception of communications. According to Section 39 of the Cybercrime Act 2015, it provides that when there are reasonable grounds to suspect the content of an electronic communications for the purpose of conducting criminal investigations and proceedings, a judge of a federal court may, upon such information through the use of an oath, number one, order a network service provider to carry out interception of communication of such context data or traffic data through the application of technical means. According to Section 39 sub 1b of the Cybercrime Act 2015, it further provides that the court may authorize a law enforcement and security agency to conduct lawful interdiction of communication to record any such content data through the application of technical means. Basically, what Section 39 of the Cybercrime Act 2015 is basically talking about is that the court may authorize any law enforcement and security agencies to carry out lawful interdiction of communication, provided that such was to conduct criminal investigation or conducting forensics while pursuing a wrongdoer. Having discussed the legal provisions for authorized interception under the Cybercrime Act 2015, can let us proceed to the legal provisions for authorized interception under the Terrorism Prevention and Prohibition Act 2022. According to Section 68 of the Terrorism Prevention and Prohibition Act 2022, it provides that the court may also authorize a law enforcement and security agencies to carry out lawful interception of communication, provided that such was for the purpose of conducting criminal investigation or tackling terrorism in Nigeria. Dear viewers, at this junction, I believe we are able to learn the legal provisions for lawful interdiction of communications under the NCAA 2 and 3, the 2019 regulations for lawful interdiction of communications, the Cybercrime Act 2015, and also the Terrorism Prevention and Prohibition Act 2022. Dear viewers, kindly don't forget to visit our website at www.harlemsolicitors.com and our various social media pamphlets at LinkedIn, Instagram, or Facebook. Thank you so much and God bless.